Good afternoon and welcome, and thank you for joining us on our Fox Williams annual data protection update. My name is Colvin Stone. I am one of the partners in our tech and data team, and I'm very pleased today to be joined by my colleagues Nigel Miller, who's also a partner in our team, Arjun Majumdar, and Claire Bowler, who are both associates in our team. And here is what we are going to cover today. We're going to get straight into it because we've got a full agenda. So next slide, please. So Claire is going to kick off with data protection reforms and meaningful recent cases, followed by Arjun, who is going to give us an overview of the ever-changing regime around international transfers, looking at recent developments. Nigel is going to cover privacy issues around employee monitoring. And last but not least, I will look at the hot topic of the day, current developments in the regulation of AI. So handing over to Claire, who will talk to us about new reforms.
Good afternoon, everyone. As Colvin says, I'll be kicking off talking about data protection reform, and in particular, the Data Protection and Digital Information Bill. This was introduced into the House of Commons in March last year, and much of the content is quite similar to the 2022 bill of the same name, which was subsequently withdrawn. Been through various stages. Next slide, please. As we can see here, and the next stage is the report stage, where there'll be a chance to scrutinise some elements of the bill and discuss further amendments, and that's yet to be scheduled. It's intended to make the GDPR more practicable and less burdensome in lower risk situations, whilst also maintaining those high data protection standards for which the GDPR is well known. It contains quite a few clarifications, on which I'm going to discuss further, and also brings several of the GDPR recitals into the operative text. Next slide, please. So this is just a quick overview of some of the changes that I'm going to discuss today. So the definition of the personal data is being clarified. Some of the areas around DSARs being clarified, and there's changes to the legitimate interest ground, that lawful basis, automated decision making, the electronic communication regulations, and the regulatory framework and role of the ICO. Next slide, please. So kicking off with the definition of personal data. So currently it means any information relating to an identified or identifiable natural person. And the bill proposes changes to the definitions so that information will only be considered identifiable where the individual is identifiable by the controller or processor by reasonable means, or where the controller or processor knows that another person will be able to obtain the information as a result of the processing. And this means, in short, that this limits identification to the controller, the processor, or any third party that's likely to receive the information, rather than the general public as it currently stands. And identification, it only needs to be by reasonable means, which means considering factors like the time, effort, and costs involved in identifying the individual by that means, and the technology and other resources that are available. In practice, often organisations can be overly cautious as to what falls under personal data and what is deemed identifiable. And hopefully this change will create more efficiencies for organisations that process data that's not possible to re-identify. Moving on to DSARs, the bill amends the exemption that controllers can refuse to respond to a DSAR or charge a fee if a DSAR is vexatious or excessive. This is a broader scope for DSARs to be refused than the existing exemption, as this is currently just for those DSARs which are manifestly unfounded or excessive. And a request can be vexatious if it's not made in good faith or if it's an abusive process. So an example might be where the DSAR is not motivated by privacy concerns, but is being used more as a pre-litigation disclosure exercise. And this then might be more open to challenge and refusal than at present. Moving on to legitimate interests, one of the changes the bill suggests is an approved list of recognised legitimate interests. as a legal basis for processing, which includes various public interest purposes, such as safeguarding vulnerable individuals, for which there's no balancing test required. So usually the controller would need to balance the legitimate interests versus the rights and interests of the data subject. And there's also scope for the Secretary of State to extend this list, and it's not non-exhaustive. Moving on to automated decision making, so not to stray into what Colvin will be discussing later on the current regulatory landscape. AI as regards automated decision making, or ADM, the bill prohibits this where there's no meaningful human involvement, except under certain conditions, including where there's safeguards enabling data subjects to obtain human intervention or to contest in decisions. The bill also clarifies that profiling is a significant factor in determining whether there has been meaningful human involvement in the decision-making process, but that profiling alone does not constitute ADM. Next slide, please. So PECA, or the Privacy and Electronic Communications Regulations, this is to do with cookies, so those pesky cookie pop-ups we often get when we go onto websites. Some of these cookie consents are going to be relaxed or proposed to be relaxed under the bill, so that websites can use cookies for, say, web analytics or automatic software updates without requiring consent from the user. Part of the changes to PECA are also stronger enforcement powers for issues arising underneath it, including the ability to award higher fines up to the level of GDPR levels, so up to 17.5 million or 4% of a company's global annual turnover, whichever is higher. And then lastly, on this whistle-stop tour of some of the key changes, there's some changes to the ICO and the regulatory framework under the GDPR. So in regards to the ICO, there's some structural changes. There's going to be an information commission body, which will be made up, which will be entirely independent and consist of a chair, a chief executive, and a board. There will also be new ICO powers to require documents, reports, and interviews, and to reject complaints under certain conditions, e.g., where the data subject hasn't first made the complaint to their controller. On the positive side for companies, perhaps, is that the bill is removing the requirement for mandatory ICO consultation for high-risk data processing activities, instead makes it voluntary, removes the requirement to appoint a DPO, data protection officer, and to perform data protection impact assessments and records of any processing activities. And instead of the DPO requirement, you instead have a senior responsible individual, but only where there's likely high risk processing. High risk hasn't actually been defined in this context, but the bill suggests that ICO must publish examples of processing types it deems to be high risk for this purpose. Next slide, please. So moving on to a couple of quick case law updates. And much of these are to do with DSARs and ICO powers. This first one is a case from October last year, Dello, the Information Commissioner, and this had it was clarification on ICO complaints. And the Court of Appeal upholding a High Court ruling that the ICO was not obliged to reach a definitive decision on the merits of each and every complaint, but instead has a broad discretion, which in this case it had exercised lawfully under the GDPR when responding to a DSAR complaint. So a quick bit of context. The claimant was dissatisfied with a response to a DSAR it had made to Wise Payments, and they complained that Wise had refused to disclose much of their personal data in response to the DSAR. The ICO advised that it was likely that Wise had complied with its obligations and no further action would be taken. The Court of Appeal discussed whether the ICO was obliged to reach a definitive decision or whether it has discretion to decide another appropriate outcome, and if it does have that discretion, whether it nonetheless acted lawfully by declining to investigate or determine the merits of the complaint. And the Court of Appeal, as I said before, held that because the ICO's principal obligations are to address and deal with every complaint by arriving and informing the complainant of some form of outcome, that outcome was an apt description of the ICO's decision just to conclude the investigation. And that's just a quote there from the ICO news release regarding the same. Next slide, please. Few more evolving DSARs. First two are EU cases, which still might bear some relevance given the similarities between the two GDPRs. The first one was where the ECJ ruled that right to a DSAR extends where the data subject requests it to the identification of the specific recipients to whom their personal data was disclosed. So they confirmed that where personal data had been or will be disclosed to these recipients, there's an obligation on the part of the controller to provide the data subject on request with the actual identity of those recipients. And it's only where it's not yet possible to identify those recipients that the controller might instead indicate the categories of those recipients, or where it might be manifestly unfounded or excessive to do so. The other ECJ one that is of particular relevance was from May last year, and it's around the interpretation of whether the data subject's right of access to receive a copy of their personal data, what that actually involves. And the EU courts in this case held that the copy meant, requesting a copy meant that a data subject must be given a faithful and intelligible reproduction of all their personal data, which has undergone processing. In this case, the complainant requested a copy of documents in a standard technical format. And in response, CRIF, as it was in this case, sent him a list and summary statement of his personal data. And the ECJ held that a copy does not relate to a singular document, but to all the personal data which it contains, and that must be complete. Third and last one I'm going to quickly go through is one that was in the High Court May last year, and it's in regards to the judicial exemption to responding to a DSAR. And this exemption has not previously been considered in any High Court or appellate judgment. In this case, the second defendant was a High Court master and a cost judge who was deciding cost proceedings in which the claimant was a party, and then the first defendant was a company providing on contract court transcripts for the Ministry of Justice during the same cost proceedings. And the claimant made DSARs to both defendants for disclosure of his personal data, and the defendants declined to provide data in response, relying on this judicial exemption under the Data Protection Act. And whilst the claimant tried to argue that certain advisory notes narrowed the scope of this, the High Court instead held that the defendants were entitled not to disclose the claimant's personal data, and that the judicial exemption should be interpreted broadly to cover all judicial functions, given the strong public interest in safeguarding the independence of the judiciary. That's all from me.
Thanks, Claire. I should say, actually, if you do have any questions, then please feel free to put those in the chat function, and we'll do our best to answer them as we go. But before we move on to Arjun, Claire, I've got a couple of questions for you, actually. So in terms of the bill, when is it likely to be enforced, do you think?
I think we said this the same time last year that it was hopefully within a year, but I think we actually mean it this time because it is definitely in its latter stages. It's only got one more reading, and then it should be at the royal assent process. So hopefully in the next 6 months, but definitely before the end of this year.
Okay. And then looking at the current regime and the bill, what do you think is going to be the impact on companies? Like, how significant are the changes, do you think?
In terms of things companies will actually have to do, I think probably fairly minimal. There's not going to be a lot of compliance costs as a result of the changes in the same way as the GDPR was. Instead, I think it's going to ease those compliance costs going forwards, and there'll be less sort of administrative burden, and hopefully it should help with sort of evolving technologies, and it kind of shows a movement of the UK government in assisting those sort of companies doing well in the future.
That kind of makes sense. I guess it's another example of the UK trying to differentiate itself from the EU in a kind of post-Brexit world, and we'll very much see that when we come on to how the UK approaches AI as compared to the EU. And we might see a similar theme in relation to international transfers. So that's a nice segue for Arjun to present the next section.
Yes, absolutely. Thanks very much, Colin. Thanks, Claire. Good afternoon. I'm going to give you an update on international data transfers. I also want to give you a general kind of summary of the law as well. So this is an area which has been in flux over the last 4 years, arguably longer. We're now sort of in a position where, dare I say, we have a little bit more certainty in this area, albeit we can probably expect more twists and turns to come in the future. But particularly if we sort of compare ourselves to where we were in 2020, when on the back of the Schrems II decision, where there was quite a lot of uncertainty, we've certainly got a lot more kind of experience in dealing with the changes that have come about in the last sort of 4 years. So now's a good opportunity to kind of take stock and look at where we are now. So what I'll do is I'll do a whistle-stop tour of the law in this area, the key updates, and what actions we recommend you should be taking in this area. Next slide, please. So I thought this flowchart might be useful in helping to summarize how the GDPR international data transfer rules work. It is a simplification, but hopefully it gives you an insight into how GDPR lawyers think when approaching this area. Starting in the top left-hand corner, when we think about restricted transfers, it's important to ask ourselves whether it's an EU GDPR restricted transfer. So is it a transfer from the EU to outside the European Economic Area, the EEA? Or is it a UK GDPR restricted transfer, so a data transfer from the UK to outside the UK? And as Colvin was alluding to, this is an important distinction to make, because, so slightly jumping ahead, when looking at appropriate safeguards and SCCs, the types of SCCs you use will depend on whether the EU GDPR or UK GDPR applies, and I'll return to that point slightly later. Assuming that it is necessary to make the transfer, and that's a really important sort of preliminary question to ask, is it necessary? The first question to ask is, has the European Commission or UK government, and depending on whether EU or UK GDPR applies, made an adequacy ruling for that country or territory? In other words, is that data being transferred to a country or territory listed as adequate? If it is, then that's great. It means you're not required to consider appropriate safeguards. If adequacy doesn't apply, though, the transferor or the exporter will need to put in place a specific set of transfer tools, or what are called appropriate safeguards. The appropriate safeguards are listed in the GDPR, but the vast majority, for the vast majority of businesses, the only viable appropriate safeguards will likely be the standard contractual clauses, or SCCs. And a lot of you listening, I'm sure, will be familiar with SCCs. If you are relying on appropriate safeguards, which will most likely be the SCCs, the transferor is also required to assess the transfer and document the transfer risk assessment. And this is something that's come out of the back of the 2020 Schrems II decision, and something that we're very much used to, having done quite a lot of these since that time. And a TRA basically involves assessing the country which is receiving the data, and if there are any particular issues or risks with that country, say due to intrusive government surveillance or lack of privacy rights, or lack of rule of law, which might make enforcing your SCCs a challenge, the parties also need to consider putting in place what are called supplementary measures to mitigate against the privacy risks inherent in that country. And you'll also see if adequacy doesn't apply and for some reason you can't use SCCs, the exporter would then have to find a derogation or an exception listed in the GDPR. And derogations tend to apply in certain specific, exceptional, or sort of one-off circumstances. So they can apply in certain circumstances, but in the interest of time and for the purposes of this webinar, I won't be covering these. Next slide, please. So hopefully that's a useful reminder of context, and I wanted to start by focusing particularly on adequacy. And the key update here really is, in July of last year, the EU and the US agreed to a new data privacy framework, or DPF. Next slide, please. Personal data transfers to the US have always been challenging. Fundamentally, this is because the US have quite intrusive government surveillance laws, which means that the privacy protections afforded under the EU are not guaranteed when someone's data is sent to the US. And the US and the EU have in recent years tried to put in place schemes which allow for the safe passage of personal data to the US. And I'm sure a lot of you will be familiar with the Privacy Shield. And in 2020, the European courts famously struck down the Privacy Shield, which left a lot of uncertainty for businesses sharing data with the US. So at the time, there's a lot of scrambling to put in place SECs and carry out the newly required TRAs. But in July 2023, a new framework was agreed. And what this means is that EU businesses going forward can send personal data to any US organization signed up to the DPF without needing to put in place SECs or carry out a TRA. So the DPF, like the Privacy Shield before it, which is supposed to afford more protection to individuals whose data is being transferred to the US and provide them with more rights under the DPF, works as a sort of quasi-adequacy ruling. A lot of the large cloud providers like Google and Amazon are signed up to the DPF, which is of course useful for businesses relying on say Google Cloud or AWS. And also from a UK perspective, the UK government, perhaps not surprisingly, I should say, latched on to the DPF and also declared it adequate. The DPF is a treaty between the EU and the US, but if you're a UK business sending personal data to a US company signed up to the DPF, you can rely on the DPF by way of this UK declared extension. But it's worth remembering that if a US company is not covered under the DPF, then the transferor in sort of the usual way needs to find an appropriate safeguard. And this goes back to putting in place SCCs and a TRA.
Arjun, just a quick question before you move on to the next topic. Obviously, you sort of mentioned this, that this is the third iteration of some form of framework for transferring between the EU and US. What are the chances or the likelihood that this might be challenged again? Have you got any insight that you can share on that?
Yeah, I mean, I guess the short answer is we're not quite sure. Well, I think a challenge is likely, but we're not quite sure what the outcome of that challenge will be. So yeah, unfortunately, the uncertainty continues. The DPF is in force now, but it's probably by no means the last word. And privacy campaigners like Max Schrems are already gearing up for another challenge to the DPF. So it is likely to be challenged. When that will happen and what the outcome of that challenge will be, we don't really know. But it's certainly something we're going to be keeping a close eye on.
Do you think if it's challenged at the EU level, could the UK still continue to recognise the DPF? So it may not have the same impact for UK businesses as it does for EU businesses?
I think that's possible, and this sort of goes to the UK deviating more away from the EU if it wanted to. So it's possible that the UK could independently recognise the DPF, but yeah, it's possible.
Okay, and just on that topic as well, we know adequacy. You mentioned it here. That is, I think, up for renewal for the UK. I think next year. Any insight in terms of whether that will be granted again?
Yeah, so I mean, so you'll see on this slide actually that the list of adequate territories is sort of combined. Technically, they should be sort of two separate lists because of Brexit. The EU and UK have separate adequacy lists. So as part of the post-Brexit arrangements, the UK recognised the European Economic Area, the EEA, as adequate, and the EU recognises the UK as adequate. But yeah, as you pointed out, the EU's adequacy decision for the UK expires in 2025. So yeah, the big question is, will the EU renew that decision, or will it just let it expire and not renew it? And I don't believe the EU has given any indication either way, but I think that the EU is waiting for the data protection reforms that Claire was talking about before
Yeah.
to actually come into force, and then the EU can actually assess what the new UK data regime looks like before then, making a decision as to whether the UK's regime is still similar to the to the EU GDPR regime. There are other factors to consider as well, like the UK's approach on government surveillance. But I think it's the UK reforms that maybe the EU are waiting on before they make a decision.
Yeah, I think that makes sense. I'll let you continue.
Okay. Next slide, please. So far I've talked about adequacy, and I've also talked about SCCs as if they are sort of one monolithic set of clauses, but there are different versions of the SCCs depending on which version of the GDPR applies, and this is the post-Brexit scenario that we're in. So the EU has its own version of the SCCs, and the UK post-Brexit has published its own version. The UK actually published two sets of clauses. One is called the IDDTA, and the other is a UK addendum, which effectively recognises the EU SECs but changes its language so that it aligns with UK GDPR. Next slide, please. So I appreciate this table might look like information overload and look a bit confusing, but not to worry about the specifics. I'll sort of talk through the key points here. So the European Commission published new EU SECs in 2021. The UK government published its set of clauses in 2022. And what both the EU and UK did when they set grace periods was that during these grace periods, they allowed businesses which were still relying on old pre-GDPR SECs to transition over to the new clauses. So if you look at the dates in the left-hand column, you'll see that those dates have now all passed. So the grace periods have now all expired. And this basically means that businesses previously relying on the old SECs should have transitioned their agreements now over to the new versions. The new versions being the EU SECs, UK IDDTA, or UK addendum, depending on which is appropriate to the arrangement. So the takeaway here is, if you haven't already done so, or perhaps you haven't revisited your SCCs in a while, it's important that you start looking into that transition as a matter of priority, given the deadlines have now passed. Next slide, please. So I'll finish by discussing what actions you should be taking, and these might be things you are doing or have done already, or you might be in the process of doing, but it's worth bringing them up in any case. So the first thing we would say is assess your international data flows if you haven't already done so. It's really important for to map out your data flows. So within your organization, you should be asking where and to whom is personal data flowing to, and for what purposes. What types of personal data are being shared abroad, and again, for what purposes. The more granular and specific you can be about your data flows, the better. And data flows mapping is important because it helps you and your lawyers, legal counsel like us, figure out which laws apply to those transfers. Is it UK GDPR, EU GDPR? Is it both? This will depend on the way your business is set up. As mentioned before, if you're still relying on the old EU SECs, then you should be prioritizing ASAP to move over to the newly published clauses. It may be that you have standard data protection terms or templates. If there are international data transfer considerations and you haven't revisited those terms or templates in a while, it may be the case that you're still relying on old EU SECs in those templates, which will need updating. If you are an international organization or an international group of companies, then you should have or should be updating your intra-group transfer agreement. And then wherever you're relying on SECs, remember, as a data exporter, you also need to conduct a transfer risk assessment, and TRAs are designed to identify risks in your international transfers, and where there are risks in your TRA, you should be considering appropriate supplementary measures to mitigate those risks. Yes, so that's I think what I wanted to cover. I appreciate it was a bit of a whistle-stop tour in what could be a tricky area to navigate.
No, certainly. Just one more question from me, Arjun, before we move on to Nigel. So in relation to international transfers, it's quite common that people use SECs and they do a transfer risk assessment, TRA. If they're following that method of compliance, does it sort of guarantee 100% compliance with the rules around international transfers, or is there still some risk?
There is still some risk, yeah. So putting in place SECs and a TRA doesn't guarantee 100% compliance, and that's just because of the whole point of the requirement to carry out a TRA is it's not just supposed to rubber stamp your transfer. The exporter is, genuinely required to carry out a proper assessment and identify risks. And if there are still underlying risks which can't be mitigated by supplementary measures, then exporters should consider perhaps not making the transfer, or if they do, they should be aware that it could be challenged or scrutinized by the regulator, which is what happened with what we saw with the Meta case last year. So there is a kind of balancing exercise that businesses need to take between the legal risks and recognizing that SECs and TRAs could, the TRA could be scrutinized by the regulator, and that's on the one side. On the other side is the sort of commercial necessity to transfer data.
Yeah, it's challenging, isn't it? I think trying to
It is,
meet the requirements. So Nigel, just on to you to talk us through privacy-related issues with employee monitoring.
Well, thanks very much, Colvin, and good afternoon, everybody. I hope you can hear me okay. So yeah, coming on to a different topic now about monitoring employees within the workplace. And this arises because the ICO did some research last year that showed that 1 in 5 employees, believe that they have been monitored by their employer, and over 2/3 of people said that they would find workplace monitoring intrusive. Less than 1 in 5 people would feel comfortable taking a new job if they knew that their employer would be monitoring them. So employees are not too keen about it. Meanwhile, with the rise of remote working and developments in technology, many businesses are looking to keep a closer eye on their workers, and this has led to an increase in the monitoring of workers, particularly in a post-COVID hybrid working situation where a lot of people are working from home for much of the time. So coming on to the next slide, please. Looking at what are the reasons why employers would want to monitor their workers? Well, there are lots of potential reasons. Probably the main one is that they want to monitor productivity and use tools to analyze or assess worker performance. Also, as you often hear, monitoring may be for training and quality purposes, quality control, or it may be to meet regulatory obligations. For example, financial services banks conducting transactions online or by phone are required to record those calls. So there may be a legal requirement for conducting monitoring. What sort of monitoring technologies are used? Well, it may be basic technologies for monitoring timekeeping or access control to the building or the offices. It may be on the desktop, it may be keystroke monitoring to track, capture and log keyboard activity, tracking how workers spend their time, looking at internet activity and keystrokes, often taking images. And then there's the use of biometrics, for example, for access controls, access to secure areas within buildings such as server rooms, or for time and attendance monitoring. So it may be by fingerprinting or iris scanning, voice recognition, or automated face recognition, use of biometrics. While data protection law does not prevent monitoring, it has to be done, of course, in compliance with data protection laws. If the monitoring is excessive and undermines employee privacy, then it's likely to intrude, undermine well-being, and contravene data protection laws. That could then stand in the way of an employer looking to rely on data obtained from the monitoring for example, disciplinary purposes, or could lead to regulatory action in the event of a complaint. That was sharply illustrated at the back end of last year in December 23, when the French supervisory authority fined Amazon France 32 million euros for excessively intrusive employee monitoring. Their Amazon's warehouse employees were given a scanner. They had to document the performance of certain tasks assigned to them, such as picking and packing. But the scanners also recorded data on their productivity and things like periods of inactivity. So the fine related to Amazon's implementation of an excessively intrusive system for monitoring performance, as well as a lack of transparency in the way they implemented it. In the UK, we've also had an example of Barclays Bank, which was accused by their staff union of engaging in excessive monitoring of employees. They had tracking software that monitored employees' activity on their computers and recording and analysis of phone calls and video meetings and the like. And the union claimed in that case that Barclays was going too far, it was becoming too intrusive. Barclays defended it as being necessary for productivity measurement and also, as I mentioned, regulatory compliance. This did go to the ICO, but they didn't progress with the investigation. There was a potential of a fine, and it didn't progress, I think, because Barclays agreed to make changes to their monitoring practices and give employees a bit more control over and transparency over what was being done. So the other development has been that at the back end of last year, the ICO issued updated guidance on employee monitoring. The previous guidance had not been revised since before the GDPR came in, so it was very out of date. Also didn't take into account, obviously, COVID and the rise in home and hybrid working. So last October, the ICO published new guidance on monitoring workers, which I'm going to look at briefly. So next slide, please. So as I said, data protection law doesn't prevent monitoring, but it has to be done in compliance with data protection law. The key factor is that there has to be a lawful basis for the monitoring, for the processing. There are 6 available lawful bases under the GDPR. No single one is better or more important than the others, but you just have to choose the one that's most appropriate. For the purposes of employee monitoring, the 2 most appropriate are, or likely to apply, are consent of the employees, or the legitimate interest ground. In relation to consent, that's unlikely to be appropriate in most cases. Firstly, because many employees would probably actually not consent to the monitoring. And if a lot of employees opt out, then it's going to be problematic and undermine the reasons for doing it. But also, it's always difficult anyway to rely on consent from employees because of that imbalance in power between the relationship of employer and employee. Employees feel compelled to agree to whatever they're being asked to. They don't really have a genuine choice. And if that's the case, then a consent is very unlikely under the GDPR standard of consent to be valid. And so therefore not something that you could rely on. So therefore, in most cases, we're going to turn to the legitimate interest ground. When considering this, you have to basically balance the legitimate interests of the business against the need for monitoring the interests of the workers. In order to do this, best practice is to document what's called a legitimate interests assessment, or LIA. So this is a document that rehearses that balancing test. The ICO stresses the ideas of necessity and proportionality with the and what might be the expectations of individual employees. They also highlight that monitoring can involve capturing special category data such as political opinions or information about employee health. Even if not specifically intended, that can happen incidentally in the course of monitoring. So it might be information within emails or on phone calls that are being recorded. And also, if you use biometric data, as I mentioned, for access control to secure areas, then that is also classed as special category data. So in that case, where you've got special category data, as well as having a lawful basis, as we just discussed, you also have to identify a special category processing condition, and that can be a little bit more problematic. One option is to rely on explicit consent. So again, looking at consent, but as we mentioned, that's probably not going to be your first choice. For special category, there is the concept of processing necessary for carrying out the obligations of an employer under law, but unlikely to be helpful for most purposes, because monitoring of employees is not generally a legal requirement. It might apply in relation to, as we mentioned, financial services regulation, but generally not, where you're looking at measuring for productivity purposes, for example. There are substantial public interest grounds for processing special category data, such as prevention or detecting unlawful acts. That could be cover, for example, if you use CCTV to try and monitor for criminal activity within your areas. So that might be applied to certain specific types of monitoring. But in many cases, none of these will apply, and it may be that the only option you have left is the availability of consent. So looking at biometric processing, for example, there's no obvious ground other than explicit consent for the processing. It can be problematic to rely on the consent, but it can also be done where you have given the workers or the employees a genuine choice, a real choice. So if, for example, you use biometric access controls to access a secure area in your building, and you look for consent to use those controls, the consent can be valid if you've offered an alternative, such as using a PIN number or swipe card, and there's no disadvantage to people who choose that alternative method. Then consent could be valid in that case, because there has been a genuine alternative offered. So that's a quick look at the lawful grounds for processing when you're carrying out monitoring. Moving on to the next slide, please. So as well as having a lawful basis of employee monitoring, you also have to comply with core data protection principles. Just a quick look at some of the points highlighted by the ICO. Fairness, of course, is a key principle. You should only monitor workers in the way that they would expect. So the difference, for example, between having CCTV inside a changing room as opposed to outside a changing room. Expectations of employees' privacy are likely to be higher at home than within the office or the workplace, because of the risks of capturing family and private life information. So you need to take into account, if you're monitoring employees working at home, that sort of issue. And in respect of proportionality, consider the difference between systematic monitoring, where you continuously monitor people, as opposed to occasional or sample monitoring where that's needed. So a number of factors to consider there. Transparency, of course, is always important, being clear with people about how and why you process their information. There are only exceptional circumstances where covert monitoring would be justified. But so generally, you must inform staff about the monitoring. You must be clear about why you're doing it and what you intend to do with the information. Normally, that would be set out in the employee data protection statement or handbook or similar type of document. So data minimization, again, always important. The possibility of collecting a lot of data with monitoring. So look at ways in which to minimize that to what's necessary. Failure to comply with minimization was a key factor in the Amazon 32 million euro fine. The French regulators said that due to Amazon's high volume operations, they accepted that it was necessary to monitor what the staff were doing in real time. But the problem was that the monitoring that Amazon implemented was excessive relative to that objective. As a result, they also said that the processing could not be based on legitimate interests because it involved excessive monitoring of the employees. So it was a failure of transparency and fairness, but there was also a failure to meet the legitimate interest standard. Data security, again, important. Look at how the data that you collect is going to be kept securely, and access to that data should be restricted only to those who need that access. So identify within the company who are the appropriate people to have access to the information you collect. For example, might be the HR team. If you're using technology which is from a third-party vendor, such as a software as a service provider, other aspects to consider would be making sure you have in place the required data processing agreement under GDPR and that you have adequate guarantees of security from those vendors. And if the vendor is outside of the UK or the EU, typically they might be US based, then that can bring into play some of the international transfer issues that Arjun has mentioned. As well as carrying out a legitimate interest assessment, it would be good practice to supplement that with a data protection impact assessment. It would be necessary to do that if you're processing biometric data or special category data, but might also be best practice in other circumstances as well. So that's really documenting the various risks and strategies that you're going to use to mitigate those risks. Finally, something that's new arising from the ICO's guidance is that they advise that as part of this assessment, employers should discuss their plans in relation to monitoring with their employees before they introduce it, unless there's a good reason not to. This can, they say, potentially avoid complaints and allows you to consider issues before they arise. Probably not something that companies have done in the past, but probably one that should be implemented for future systems that are being introduced. So as a quick summary, next slide, please. What are some practical steps and takeaways from this? Well, as we've discussed, looking at the scope of the monitoring to ensure that what you're doing is appropriate to your objectives and not excessive. Updating and documenting your legitimate interest assessment and possibly data protection impact assessment as well. Looking at your employee privacy notices and the related policies to make sure that you've got full transparency on the data that's being collected and the purposes and so on, and what are the legal basis for the processing. Discussing your plans for monitoring with workers before implementing them, and finally checking your contracts with vendors who provide monitoring software services and who may process data on your behalf. So that's a quick overview of compliance and best practice in relation to employee monitoring based on the recent ICO guidance. Thank you, and I'm now going to hand back to Colvin.
Thanks, Nigel. So I'm going to talk about the current situation with regulation and AI. So next slide, please. I'll just canter through this in less than 10 minutes. So the first point I kind of want to make is where are we right now? And there is a little bit of a misunderstanding that AI is not regulated, and that's not actually the case. It's not regulated directly, but it is challenging to imagine any AI system that doesn't use personal information. So, where an AI system is using personal information, and that could be in terms of training the algorithms or actually in producing outputs or decisions, then it will be regulated by the GDPR. But there are also specific rules in the GDPR that do apply to AI type systems. It's also indirectly kind of regulated by the Equality Act. So where you've got decisions using AI that may impact an individual and what we call sort of protected characteristics, then it also could be regulated by the Equality Act, certainly in the UK, in terms of any decisions or outputs that are generated by that AI system. And of course, we have more regulation coming. So the EU is really kind of leading the way in this, a little bit like the GDPR, where the EU wanted to really set the agenda for the protection of personal information. It is doing the same with AI, and also with AI has sort of extraterritorial effect, which is very similar to the GDPR. So it's the EU looking to almost export its laws around the world. The UK and the US are following a different approach, and they are looking at non-statutory principles. Again, from the UK perspective, this is very much designed to define the UK as pro-business, pro-innovation, pro-technology in a post-Brexit world. So next slide, please. So we're going to talk about the EU AI Act first. So this is a really all-encompassing, comprehensive framework, which is really designed to ensure the safe and ethical development and deployment of AI. And it's really AI that's used within the EU, and it should come into effect in about 2 years. So the text has been finalised, but we're still waiting for it to be published. And as soon as it's published, we've got 2 years until implementation. In terms of scope, it defines AI quite broadly. So it's any software that performs human-like intelligence. So it will cover things like general AI, ChatGPT, Bard, Copilot, which are becoming very prevalent at the moment. And it applies to both AI developed within the EU and AI that is developed outside of the EU, but ultimately is used in the EU. So it has that characteristic of extraterritorial effect, very much like the GDPR. So it really regulates where the activity occurs. So if you're using AI in the EU as a UK business, for example, either because you're selling to customers or because you have operations in the EU, then you will be subject to the EU AI Act. It adopts a risk-based approach. So what it does is it characterizes AI into four categories. So unacceptable risk, high risk, low risk, and no risk. Unacceptable risk is considered to be highly dangerous and is just prohibited. High risk, which is where a lot of the focus around compliance will be centered, really looks at significant harm potentially to individuals or where it might impact fundamental rights. So examples are in areas of recruitment, employment, financial services, credit scoring, for example, assessing loan applications. So these types of AI are going to be subject to quite strict obligations. So things like documenting requirements around the AI system's capability, its performance, carrying out a conformity assessment, so it needs to comply with certain technical standards. So very similar to the CE marking regime that you have with certain goods and services like electronics. There will be a conformity assessment. You'll need to meet transparency and explainability requirements. It will need to be subject to human oversight. So human intervention may need to be available, will need to be available to ensure any decisions are subject to human oversight. And there are requirements around ensuring accuracy and robustness. Low-risk systems, the main obligations really center around transparency and explainability. The Act also emphasizes the importance of data quality, security, and privacy in AI development. So it will require AI developers to use high-quality data. That really impacts on outputs and dealing with issues around hallucination and discrimination and bias. And will also obviously need to comply with the GDPR. So in terms of enforcement, it's very similar with other EU regulation at the moment. Fines up to 35 million or 7% of worldwide turnover, whichever is higher. There's also the ability to ban potential systems that don't comply with the AI Act. There are two main protagonists within the EU AI Act. So providers and users, they have different obligations. The ones I've just run through are really focused on providers. Users, not surprisingly, will have obligations centered around transparency and explainability. Okay, next slide, please. So in terms of the UK approach to AI, as I said, it's very much non-statutory. They've developed through a white paper a set of principles ensuring safety, security, robustness, transparency and explainability, fairness, accountability and governance, and contestability and redress. So quite similar at a principle level between the EU, and you also find similar principles at a US level. And what the UK is doing is it's really asking UK regulators to take this guidance and apply it to its own regulatory guidance. So the FCA, for example, will be responsible for taking the UK's principles and working into its regulatory guidance. So it's very much going to be a sectoral approach to AI regulation, and up to individual regulators to decide ultimately how they regulate. So we'll start to see, guidance from the FCA in particular in terms of how they regulate things like credit scoring, assessing loan application, and creditworthiness, sort of generally. Next slide, please. So lastly, as I mentioned, AI is currently regulated under the GDPR. If you're using an AI system, there is already obligations to ensure that you're being transparent with individuals. Normally, that needs to be contained in the privacy notice. And that's essentially to allow individuals to exercise choice. But typically, you need to explain how the AI works, what data you're collecting, and why. And lastly, automated decision making. So AI can be used to make automated decisions. So this could be in relation to credit scoring, for example, or a recruitment decision. In essence, if it legally affects an individual, or if it has a sort of similar significant impact, then ultimately you can't carry out that automated decision making unless you've got the individual's consent, unless it's necessary for performance of a contract, or unless it's authorized by law. So if you're carrying out automated decision making that ultimately impacts an individual in a significant way, then you do need to either have the individual's consent or it needs to be necessary for performance of a contract or authorized by law. So there is already some regulation around AI. And where that's the case, you always need to implement appropriate safeguards in order for a individual to ask a human to review a decision and ultimately contest it. So next slide, please. We've done a little bit of Q&A through the session, but that really brings us to an end of our webinar today. We hope you enjoyed it. Thank you to Arjun, Claire, and Nigel for their contribution. If you do have any questions, please feel free to reach out to us by email or alternative means, and we'll be more than happy to respond. Just to say, the webinar is being recorded, and we'll circulate a copy of the slides and also a link to the recording. But thank you so much for joining, and we hope you have a good rest of day. Thank you.